Yes, sir.
Yes, sir. I thank Bar Council of Maharashtra and Goa, Chairman, Vice Chairman, all the members, coordinators, and especially Dr. Uday Varunjikar sir for giving me this opportunity and making me a part of this virtual online lecture series. So it started, I think, on 29th, and the topic which is allotted to me is sale of goods and related provisions relating to consumer protection. Is screen is visible, sir?
Yes, sir. Clearly visible.
Yes, yes. So, as I have been told, the written test will be, there will be two papers. One will be MCQ, that will be of 100 marks, and the time allotted is 2 hours. So general knowledge questions will be 20 marks. There will be 20 marks for constitution provisions, and other various consumer laws related will be having 40 marks. So in all, there will be 100 marks MCQs will be on these three subheads. And paper 2 will be descriptive, which is already been discussed by various guest lectures. That is 50 marks. It will be divided into two parts, 50 marks essay and case study will be 50 marks. And the students who will be qualified for this exams, they will be viva voce exam of 50 marks. So accordingly, there will be selection. So here, these are the 10 laws which are there, which is having 40 marks weightage. So you might be seeing the notification. So the 40 marks will be based on these acts which are related to consumer protection, apart from Consumer Protection Act. So at the end, we will also discuss what are the expected questions to be asked. The topic which is allotted to me, that is sale of goods. So let us start with Sale of Goods Act. So the Sale of Goods Act, it is important, and it was passed in 1930 as it regulates the rights and duties of parties involved in a contract for sale of goods. Previously, you will see the provisions were given under section 76 to 123 of Indian Contract Act. But due to increase in mercantile transactions in the wake of rapid industrialization, there was need that there should be a separate act. And in the year 1930, a new act was enacted which contains detailed provisions which regulates the sale between the buyer and seller. And it is based on English Sale of Goods Act 1893. The main objectives of Sale of Goods Act is to provide a legal framework for the sale of goods. That is, it defines the rights and obligations of buyer and seller in a contract for sale of goods and provides for transfer of property in goods. So it is necessary first to know for what purpose the Sale of Goods Act was passed. So the main purpose is that there should to regulate the rights and duties between the buyer and seller. Before 1930, also during British period, so this is one of the steps taken by Britishers to enact laws which are protecting the rights of buyer as well as seller. There are many laws which were passed during British period, even the Law of Torts, Indian Contract Act, the Agriculture Product Act, the Drugs and Cosmetics Act, and so on. And only after independence, we are now having a Consumer Protection Act, that is 1986, which was again reenacted due to development in internet and technology. There was need, and now in 2019, a new act, that is Consumer Protection Act 2019, is passed. So we'll concentrate what has been there in the Sale of Goods Act and what protections has been given to the buyers. So the next objective was to protect the interest of both buyers and sellers. It gives certain conditions, warranties. It ensures that the goods should be of certain quality, fit for the buyer's purpose. And if it is sold, sale by say a sample or description, it should correspond to sample and description. Otherwise, the buyer can have a right to reject the goods and he can claim damages. Other objective is to promote fair dealing in commercial transactions. So it provides for remedies in case, so if there is a breach of contract, which includes right to reject the goods, claim damages, and terminate the contract. And last, as it is a commercial contract, and as per the Arbitration Act, commercial transactions, all commercial transactions can, if the parties agree, they can refer the matter to arbitration. So the parties to contract of sale can opt for alternate disputes also, such as arbitration and mediation. So these are the objectives of Sales of Goods Act. If we see the objectives of consumer protection, the main objective is to protect the consumers from unfair trade practices. If there is any restrictive trade practices, there is a misleading advertisement, if there is any defect in goods. So the main concentration or to consumer education, to provide redressal agencies. So with development, now we are having a pure consumer protection law, but during this period, the Britishers tried to give some protection to the buyers. So we'll discuss in the coming chapters what sort of protections has been given by Britishers to the buyers to save them from unfair trade practices from the sellers. So the following table illustrates the various sections which are there in Sale of Goods Act. So there are all 7 chapters. Chapter 1 is dealing with definitions. Chapter 2, what are the provisions relating to formation of contract. Chapter 3 will deal with transfer of property between seller and buyer. That is a crucial point which will determine the rights and liabilities of buyer and seller. Chapter 4, once the contract is made, how it will be performed, how there will be delivery of goods, how there will be payment. Everything will be as per the contract or as per the provisions given under section 31 to 44. Again, there is some rights given to an unpaid seller, that is given from section 45 to 54. Next chapter deals with if there is a breach of contract, either there is a breach of contract by the seller or buyer, what remedies the seller is having and what remedies the buyer is having, we'll discuss. And the last chapter deals with miscellaneous provisions. So let we start with the first chapter, that is definitions. Section 2 is confined to some definitions, that is buyer. First definition, section 2, subsection 1 defines buyer. Buyer means who buys or agrees to buy goods. So if we compare the definition with consumer, so here no specific other terms are given, but in the definition which is given under the Consumer Protection Act, consumer means a buyer of goods for consideration and who has which is paid or promised, partly promised and partly paid, and a beneficiary of such goods, and who is not, and it does not include a person who is using for commercial purpose. But here, if we see, it is only given buyer means a person who buys or agrees to buy goods. In 2019, another word was inserted in the definition of consumer, that due to internet, now everything we are doing online. So now online transactions, if the buyer purchase the goods online with the medium of internet, he is also considered to be a consumer, provided he is purchasing the goods for his own consumption or for the beneficiaries with the permission of the person who buys the goods for consideration. So it is clear that the definition which is given under the Sale of Goods Act, it is not confined to the consumers. So every consumer is a buyer, but every buyer may not be a consumer because he may purchase the goods for commercial purposes. So here the buyer, the definition is buyer is wide as compared what is defined under the Consumer Protection Act. The other definitions are delivery. So the main point in a contract of sale is there is a delivery of goods, means there should be a voluntary transfer of possession from one person to another. Another is deliverable state. Goods are said to be in a deliverable state when they are in such state that the buyer would, under the contract, be bound to take delivery of them. So the property in goods transferred only when the goods are in a deliverable state. So if there is a future goods which are not in a deliverable state, there is no transfer of property, and it only means an agreement to sell and not a sale. And when it will be sale, when the goods are ascertained and they are put in a deliverable state, and then the buyer is taking the delivery and there is transfer of property, that is ownership from seller to the buyer. And then we can say what the risk passes with the ownership of property. Later on, we'll discuss when the risk passes, that once the person becomes the owner, the risk passes, the risk is with the owner. So even the goods are with the possession of seller, the risk passes with ownership. So these are the other definitions. That is, document of title to goods includes bill of lading, dock warrant, warehouse keeper's certificate, wharfinger certificate, railway receipts, multimodal transport document, warrant or order for delivery of goods, and any other document used in the ordinary course of business as a proof of possession or control of goods. So if the buyer is having a custody of this document of title to goods, the warehouse keeper or any other carrier, they are obliged to give the goods to that particular person who is having these documents. So that's why it is called document of title to goods. Another is fault, means wrongful act or default. So whether it is a fault of seller or buyer, both are responsible. So if there is a wrongful act committed by seller, the buyer can sue. If the wrongful act is committed by buyer, the seller can sue. Future goods means goods to be manufactured or produced or acquired by the seller after making of a contract of sale. Next definition is goods. Goods means every kind of movable property other than actionable claims and money, and includes stock and shares, growing crops, grass, and things attached to or forming part of land which are agreed to be severed before sale or under the contract of sale. So the main subject matter of contract of sale is that there must be goods, and every movable property other than actionable claims, means the suits, the claims which can be taken by filing, actionable claims which can be recovered by filing a suit, it cannot be a subject matter of contract of sale, but they can be assigned, and money. So these are the two exceptions, but rare coins can be a subject matter of contract of sale. A person is said to be insolvent who has ceased to pay his debts. So this is all you know, who is not able to pay his debts, he is an insolvent. And another definition is mercantile agent, means who is having an authority to sell or purchase goods on behalf of the buyer or seller. And price here means it should be in terms of money and not in terms of anything. So there no barter is allowed in case of contract of sale. So there should be some money for making a valid contract of sale. So another definition is property, means the ownership in the property, the general property, and not merely a special property. Means, for example, pledge. In pledge, we are only giving a security. So that is a special property. But in case of transfer, in case of sale, in order to make a sale, there should be a transfer of general property and not a transfer of special property. Another thing is quality of goods. So that is also defined under Consumer Protection Act. What is the defect in goods? So here quality of goods includes their state or condition. So whatever has been accepted at the time of contract, if it is not as per the quality, whatever is decided at the time of contract, the buyer can reject the goods and he can claim compensation. Seller means a person who sells or agrees to sell goods. Specific goods means goods identified and agreed upon at the time a contract of sale is made. So if the goods are already there and it is ascertained and the sale, a contract is made, the ownership in the property is immediately transferred to the buyer and the risk also transferred to the buyer. So these are the definitions, the terms which are not defined under the Sale of Goods Act, but which are there in the Indian Contract Act. They are still to be followed while making a sale of goods under the Sale of Goods Act. So these are the important definitions which are there, which we will use in the coming chapters. So to make them clear, it was necessary to discuss these definitions. What do you mean by buyer? What do you mean by seller? Property, general property, quality of goods, specific goods, future goods, and so on. The next is formation of contract, that is section 4 to section 17. So the next chapter is how the contract of sale is made. Section 4 defines sale and agreement to sell. A contract of sale of good is a contract whereby the seller transfer or agrees to transfer the property in goods to the buyer for price. So there may be a contract of sale between one part owner and another. So section 4 subsection 1 makes it clear that in a contract of sale, there may be a sale or agreement to sell. And if, for example, there are two partners and they are holding a property jointly, one partner can also sell his property, his part to the other partner. So there can be a sale between one part owner and another, and it is a valid sale. So it may be a conditional or it may be absolute. So if there is any condition that the payment should be made in advance, so it is a conditional transfer contract of sale. If there is no condition, it is absolutely, and as soon as the contract is made, the property in the goods is transferred to the buyer. Subsection 4, subsection 3 defines sale. When the property in goods is transferred to the seller to the buyer, from seller to the buyer, the contract is sale. And when the goods, a transfer of a property in the goods is to take place in future, subject to some conditions, thereafter to be fulfilled, the contract is called agreement to sell. So in sale, the property is immediately transferred to the buyer, but in agreement to sell, and it is clear that agreement to sell is always when there is a future goods or there is some conditions to be fulfilled, and then only when the conditions are fulfilled, then only it will become a agreement to sell. Next is when agreement to sell becomes a sale when the time elapses or the conditions are fulfilled subject to which the property in goods is to be transferred. For example, where B agrees to buy a car from Maruti Motors in the month of June 23 and pays some booking amount, but delivery will be take place when it is launched in the month of August 23, it is an agreement to sell. So when the car is launched by the Maruti Motors and the buyer pays the remaining amount, then and the car is delivered in the month of August. So when these conditions are fulfilled, the agreement to sell becomes a sale. So this is very important because the buyer, the rights and duties are only, we'll discuss later on what are the consequences if we are making a sale and what are the consequences if you are making an agreement to sell. So there must be two parties for agreement for a contract of sale. There must be two parties. There must be an agreement. All the essential elements must be present. The subject matter must be goods, movable goods. We have already discussed the definition of goods. It can be patents, copyrights, trademarks, oil, gas, motor, vehicle, ships, and also electricity. There should be transfer of property or owner, that is ownership in the goods from seller to buyer, and there should be a price. So these are the 5 essential elements to make a valid contract of sale. That is, there must be seller and buyer, there must be agreement, all the essential elements of contract must be present, there must be goods, there must be transfer of property and price. So these are the difference between sale and agreement to sell. We have already discussed what is the definition. The property in case of sale is immediately transferred, but in case of agreement to sell, after fulfilling some conditions, the property is transferred. For example, S sold 10 bags of wheat to Y against payment of 10,000. So it is the wheat is ready and it is immediately transferred. But in case of agreement to sell, X agrees to sell 10 bags of wheat to Y for rupees 10,000 after getting the stock. So now the stock is not with the X. If as soon as he gets the stock, he will transfer the property and the agreement of sale becomes a sale. So another point of difference is it is an executed contract. It is an executory contract. In sale, it creates a right in rem. That is, once you become the owner of goods, you have right against the whole world. Nobody can interfere. But in case of agreement to sell, you are not becoming the owner of goods. You are having only right against the seller if he is making some breach of contract. The seller can sue the buyer in case of breach for the price as well as for damages. But in case of breach of agreement to sell, he can only sue for the damages and not the price for goods. GST is applicable in sale, but GST is not applicable in case of agreement to sell. In case of sale, as that ownership is transferred, the seller has no right of resale. But in case of agreement to sell, the seller has right of resale. And last, if the goods are destroyed in case of sale, the risk, even it is in the possession of seller, as the transfer of ownership is there, the liabilities is of the buyer. But in case of agreement to sell, the loss fall on the seller, even though the goods are in possession of the buyer. So it is very crucial to know why it is important to differentiate between sale and agreement to sell, because in agreement to sell, the property in goods is not transferred, so the risk is with the seller. But whereas in sale, the agreement in sale, the property is good is transferred to the buyer, so the risk of loss to the goods is with the buyer. So that is very important to define the rights and obligations of party, whether it is a sale or agreement to sale. Now, section 5 is how the contract of sale of goods is made. So it is generally we have seen in Indian Contract Act, there must be offer from one side, there must be acceptance from other sides. There may be that the goods and price of goods must be concurrent. It must be paid immediately or it may be postponed. The contract may be in writing or it may be oral, but to avoid future disputes, it is preferable that the contract should be always in writing. So only that much is given under section 5, that how the contract of sale is made, that it can be by offer from one side and the acceptance from other side, and other conditions can be decided by the parties, that there may be immediate delivery of goods or there may be immediate payment of price, or it may be in writing or it may be in oral. Now, next is subject matter of goods. We have already discussed. Subject matter of goods is subject matter of sale. A contract of sale is goods. It may be existing goods or future goods. Existing goods means which are owned and possessed by the seller at the time of contract of sale, and future goods means the acquisition of which by the seller depends on the contingency. So it may be it may be acquired by a seller in future. So and it is clear from section 6 that whenever you are making a contract for future goods or contingent goods, it is not a sale and it is operates as an agreement to sell. Section 7. So section 6, it is clear that the goods may be existing goods or future goods. If there is an existing goods, there is immediate delivery and there is a sale. And in case of future goods, the goods are to be acquired after the contract of sale is made, and it is termed as agreement to sell. Section 7, goods perishing before making of contract without knowledge of seller, the contract becomes void. So if suppose A contract to sell is horse to B for certain price, but at the time when the contract is made, the horse is died. So the fact is not known to the seller. Here the contract becomes void. And section 8, goods perishing before sale, but after agreement to sell without any fault on the part of seller or buyer, the agreement is thereby voided. So it can be resigned. So that is not relevant, but we have to cover all the sections. That's why I'm discussing that section 6, 7, and 8 deals with the subject matter of contract of sale, that the subject matter of contract of sale may be existing goods, future goods, or contingent goods. Next is how the price will be ascertained. So how the price will be decided. So it is clear that the buyer and seller will decide as per the contract. And if it is not decided, the buyer has to pay a reasonable price. For example, you can take the example of sugar. So if the A is supplying sugar to B, 100 kilos of sugar to B, and the price is not fixed, is ascertained by the seller and buyer. So he can pay a reasonable price, means whatever the market price is prevalent on that particular date, he can see and he can pay that reasonable price. So what is a reasonable price is a question of fact, dependent on the circumstances of each particular case. So it is necessary that at the time of making a contract of sale, the price should be ascertained by the parties. If it is not, the buyer will pay a reasonable price. Section 10 is agreement to sell at valuation. So where there is an agreement to sell the goods on the terms that the price is to be fixed by the valuation of third party, and the third party cannot or does not make such valuation, the agreement is thereby voided. So section 10 is that when the contract of sale is dependent upon the act of third party, that he will take the value and then it will be made by the buyer and seller. In that case, if he fails, the contract will be avoided. provided if the goods, some goods are delivered to and appropriated by the buyer, he shall pay a reasonable price. So if some goods are already parted to the buyer, he will pay the reasonable price. But if the third party is prevented either by the seller or buyer in taking the valuation, the party at fault will be liable to the other party. That is, the party not in fault may maintain a suit for damages against the party in fault. So this is section 9 and 10, which is relating to the price, how the price will be decided by the parties while making a contract of sale. So with this, we have completed how a contract of sale and agreement to sale has been made, what are the essentials and what is difference between sale and agreement to sale. Now, the main point which relates to the protection of buyers is conditions and warranties. So, the most important topic, if we see, this is conditions and warranties under the Sale of Goods Act. And this is referring the protection of buyers for any unfair practices from the seller. So this was the step taken for the first time while passing the Sale of Goods Act to protect buyers from sellers. The provisions are given from section 11 to 17. So what do you mean by stipulation? So while making a contract of sale, there may be certain terms or conditions or negotiations between the parties. Some negotiations may be very crucial, and if they are not followed or the conditions are not followed, the other party can reject the goods and claim damages. But some terms or stipulations are collateral. They are not so important, but in that case, if it is not followed, the buyer is not having right to reject the goods, but he can only claim damages for not fulfilling that conditions or terms. So what is section 11? So in a contract of sale, usually parties make certain statements or stipulations about goods under a sale or purchase. These stipulations in a contract of sale are made with reference to the subject matter, that is goods. There may be a condition or a warranty. So here, condition is not what we think in a general sense that we are having 2 years warranty or 2 years guarantee. So here, the condition or warranty is some stipulations or terms which is made at the time of contract of sale. And some are very important. If they are not followed, the buyer is having right to reject the goods and claim damages, and some are collateral. In that case, he will not have right to reject the goods, but he can have damages from the seller. So section 11, stipulation as to time. So what is section 11 says that the general rule is stipulation as to time of payment is not a condition. It is not the essence of contract. So if the delivery is not in the payment of goods is not in time, the seller cannot reject or cannot unless there is a contract to the contrary that the time will be the essence of contract. The seller cannot repudiate the contract or he cannot reject the contract unless there is a specific mention in the contract. So it is given under section 11 that the general rule is the time of payment is not essential, and the seller can only claim damages and he cannot reject or he cannot avoid the contract. But if it is specifically given in the contract that the time of payment will be essence of contract, in that case, the seller can have right to avoid the contract and he can claim damages from the other party. But time of delivery of goods are usually the essence of contract. So there is a difference between time of payment and time of delivery. So if time of delivery is given, it may be essence of contract, that is main thing which will be considered whether to contract is to be accepted or not. But it will also depend the contrary intentions of the parties while making the contract. So section 12 is conditions and warranties. So whatever the terms, stipulations, it may be either a condition or a warranty. That is section 12, subsection 1. Section 12, subsection 2, a condition is a stipulation essential to the main purpose of contract, the breach of which gives uh, rise to the right to treat the contract as repudiated. So if there is a breach of condition, it is essential to the main purpose of contract. The seller or the buyer can reject or he can avoid the contract and he can claim damages. Whereas warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives rise to claim for damages, but not a right to reject the goods and treat the contract as repudiated. So with this, it is clear that as compared to warranty, condition is more important because it is essential to the main purpose. We'll take an example which will make the point clear. And in case of warranty, it is collateral and which you cannot avoid the contract, but you can claim damages. So we'll take an example. A lady orders for a red sari to the seller to be sent by a registered parcel and that she will pay the price by 15th June, the day of her marriage. In this illustration, the stipulation regarding the color of sari as well as the date are essential to the main purpose of contract and are conditions. So if the delivery is not on 15th, which before 15th, which she wants to wear on her marriage, so it is a condition. If it is received after 15th, then it is of no use. So it is a condition. It is essential to the main purpose of contract. So she can avoid and she can claim damages. And the color sari is also a condition. Whereas stipulations regarding the time of payment of price and the mode of dispatch of goods are not essential to the main purpose of contract, but are only collateral and they are warranties. So time of payment can be delayed or mode of dispatch can be any other mode he can say. And for this, it is not essential to the main purpose of contract. For that, she can only claim compensation, but he cannot reject the goods. So that is a sort of protection given to the buyers by making certain conditions and warranties. Section 4, subsection 4 says that whether a stipulation is a contract of sale, in a contract of sale is a condition or warranty depends upon each case on the construction of. So we'll take another example. If suppose a person wants a suit to be, he orders a suit in the month of November to be used in the month to be used in the following winter season. So though the delivery is in the month of November, if it is delayed, in that case, it is not a condition. So the construction shows that the suit which is ordered in the month of November, it will be used in the following winter season. So even it is delayed, it is not an essential to the terms of contract, and it will be so on the construction of contract, it will depend whether it is to be considered as a warranty or a condition. Okay, so with this, it is clear that what is conditions and warranties. So section 13 is when conditions to be treated as warranty. So it depends upon the buyer. The option is given to the buyer, voluntary waiver of condition. Okay, so if you are ordering a cake, a chocolate cake, and wrongly they are delivering a pineapple cake, so it is up to you. You can waive that. Okay, I will have this, and you can treat it a warranty instead of a condition. And you can, instead of rejecting, you can claim damages. Okay, I am accepting the goods. I will claim damages from you as you have not comply with that condition. So you can treat a condition. It is up to the buyer, that is provided under section 13 by waiver. He can waive his right and he can claim a condition as a warranty. And another mode is by acceptance. So where a contract to sale is not severable. So when and the buyer has accepted the goods or part thereof, the breach of any condition to be fulfilled by seller can only be treated as breach of warranty and not as a ground for rejecting the goods unless there is a term of contract express or implied to that effect. So if you have already, the buyer has already accepted the goods and they are not severable, in that case, a breach of condition can be treated as a breach of warranty. So it is up to the sale buyer to consider a breach of condition as a breach of warranty. Now, the most important topic, implied conditions and warranties, which are given under section 14 to 17. When any stipulation is inserted in the contract at the will of parties, it is said express conditions and warranties, but there are certain stipulations which are inserted by law. They are safeguard the interest of buyers from the rule caveat emptor, that is, which is a privilege to the seller. So what is caveat emptor, which is defined under section 16, that buyer be aware. So the general rule of common law of sale is that except in case of fraud, the buyer purchase at his own risk. So he is not depending upon the skill and judgment of buyer, seller. So whether the goods which he is purchasing, whether it is suited to his purpose or not, he is relying on his own judgment. And afterwards, if it comes, it is not suiting his purpose, he cannot blame the buyer, and that is why it is called let the buyer be aware, that is caveat. The rule is caveat emptor. The next is this principle which was prevalent during the times when the goods were brought in the open market. Now you see today's scenario. Now everything is online. Amazon, Zomato is there. Even after having a dinner, it has been observed that even it is only 100 meters away from your home, the persons are ordering online any juice or any pan after having a dinner. So that situation is now prevalent. So the rule of caveat emptor was only applicable when the buyers were having opportunity to examine the goods in the open market. But now everything is online, and because of that, now the rule has been changed from caveat emptor to caveat venditor. Now instead of caveat, that is buyer be aware, the seller be aware before selling the goods, because now the buyer is not able to examine the goods because of this internet and digital technology. So the leading case was Ward versus Hobbs. In this case, a number of pigs were sold in an auction in which the seller excluded all warranties with respect to any defect or description. So the buyer has purchased in an auction certain pigs and there was exclusion of all conditions and warranties. So it was up to the buyer to examine whether the pigs, whatever he is purchasing in the open market, is suited to his purpose. So not only most of the pigs, said pigs bought by the buyer died, they also infected some of the pigs of the buyer. The action brought about the buyer was rejected as there was no breach of any implied condition or warranty. So this is the leading case on the rule of caveat emptor, which was prevalent in olden days when the buyers were able to purchase the goods in the open market. But now, due to consumer protection law, the rule has been changed that now this, instead of buyer be aware, now the rule is seller be aware, that is caveat venditor. So I will ask the participant to concentrate on this particular aspect, which is the questions most probably in the exam. It will be on these aspects, that is caveat emptor. Some of the questions will be on caveat emptor. So we'll discuss later on at the end of session what type of questions can be asked in the exam from this Sale of Goods Act. So the exceptions to the doctrine are implied conditions as to title. Section 14 to section 17 is mentioning they have enacted, the law has enacted certain exceptions to the doctrine of caveat emptor to protect the buyers, that whenever you are purchasing the goods, there is an implied condition that the seller is having title to goods. Second, there is an implied condition in case sale by description, that the goods correspond with the description. So if I am ordering the goods that I want a Dell computer of a particular configuration, that is 8 GB RAM and 512 SSD. In that case, if the seller is delivering HP laptop and with other configuration, so there was a description given by the buyer, but it was not corresponding to the description. So the buyer can reject the goods, as it is the main implied condition that the goods must correspond with the description. So there are many safeguards given to the buyer under section 14 to 17 by the law in order to protect from the seller. So another safeguard is implied condition in sale by sample as well as description. So if the sale is by sample as well as description, it must correspond both to the sample as well as description. So it must be of a particular sample, for example, a red color or a particular pattern, and a description which was given by the buyer. So if it is of a particular description, but it is not corresponding to the sample, still the buyer can reject the goods because it is the condition of implied condition in a sale of sample that it should be correspond to the sample is not followed by the seller. Next is implied condition in sale by sample, that is section 17. A contract of sale is a contract for sale by sample where there is a term in the contract express or implied to that effect. In the case of contract for sale by sample, there is an implied condition that the bulk shall correspond with the sample and the buyer shall have a reasonable opportunity of comparing the bulk with the sample. So whenever you are purchasing the goods by sample, there is an implied condition. So whatever the samples has been shown to the buyer at the time of contract of sale, there is an implied condition which gives protection to the buyer that the goods, the bulk should correspond with the sample. Next is implied condition as to quality or fitness. The general rule is the seller is not liable for what purpose or whether the goods are suited or fit to the purpose of the buyer. But if the buyer is relying on the judgment and skill of the seller, there is an implied condition as to quality or fitness that I want of that quality. If I want a racing car, a car which is suited for racing purposes, and I am relying on the skill and judgment of seller, and if the seller is giving me a wrong car which is not suited to for racing purposes, so it is an implied condition and it is a breach of condition, and I can reject the goods and I can claim damages because I have relied upon the skill and judgment of the seller. So this is so the general rule is that you are not the seller is not liable for whether the particular thing is suited for the seller's purpose or not. But if the seller is relying on his judgment, the buyer, in that case, the seller is liable for such breach of condition. Next is implied condition as to merchantable quality. When the goods are brought by description from seller who deals goods of that description, there is an implied condition that the goods shall be of merchantable quality. So ordinarily, it means the goods should be such as would be commercially sellable under the description by which they are known in the market at their full price. So if a first quality wheat, I am asking for first quality wheat. So if due to moisture, it loses the quality. So it is having not that much of merchantable quality and it will not get that much of price which is expected. So in that case, there is a breach of implied condition of merchantable quality. Another is implied condition as to wholesomeness. So in case of eatables and provisions, in addition to the implied condition as to merchantability, there is another implied condition that the goods shall be wholesome. For example, milk. So it is a type, so you know the purpose for which the milk is used, it is consumed. And if it is containing some germs and which makes the person ill, in that case, there is a breach of implied condition as to wholesomeness. So in Consumer Protection Act in 2019, it is very important to know that in the definition of goods, they have included the term foods. Previously, the term food was not included in the definition of goods. Now, in 2019, the word food has been inserted, that the goods includes food, and there is implied conditions relating to food, that it should be of wholesomeness. That is, it should clear in all, it should be suited in all respects. So these are the implied conditions, and there are some implied warranties also, that is of quiet possession. So if I am having, I am taking some vehicle from you, uh, I purchase a vehicle from seller, so it is an implied warranty that I should be having a quiet possession of that vehicle or a mobile. So if afterward it turns that the mobile was stolen or the vehicle was stolen and I was interfered by the true owner, so there is a breach of implied warranty of quiet possession. Next is implied warranty against charges or encumbrances. So there should be no charge. The whatever the buyer is purchasing goods, it should be free from any encumbrances or charges. So if there is any encumbrances and the buyer has to pay that charges to the person with whom there is some charge with the goods, in that case he can, there is a breach of implied warranty against the charges or encumbrances, and he can claim damages from the seller. And last is warranty to disclose dangerous nature of goods. That is also there in Consumer Protection Act. So whenever you are dealing with some hazardous or injurious nature of goods, it is the duty of seller to disclose the dangerous nature of goods. So if it is not, and afterwards the buyer is injured, in that case he can claim damages for breach of implied breach of warranty to disclose the danger nature of goods. So with this we have completed this what are the implied conditions and warranties. This is most important chapter which is relevant to consumer protection, and which were inserted by law to give certain sort of protection to the buyer from the seller. The another chapter 3 deals with effect of contract, that is when the transfer of property is there between seller and buyer. We will go fast. That is section 18 to 13. The main reason to decide, it becomes very important to know the exact time of transfer of ownership of goods from seller to buyer for the following reasons. Because to determine the rights, who is at risk, whether the seller will pay if there is loss to the goods or whether the buyer will pay for the loss of goods, it depends whether there is a transfer of property, that is ownership of goods from, whether who is having the ownership of property, whether it is with the seller or with the buyer. The provisions are given from section 18 to 30. So the reasons are: who shall be at risk, who can take action against the third party, whether a seller can sue for price, in case of insolvency of buyer, whether the official receiver or assignee can take possession of goods from seller if the buyer is, the transfer of property is already given to the buyer and possession is with the seller. In case of insolvency of seller, whether the official receiver or assignee can take possession of goods from buyer if the transfer of property is not, the ownership in property is not transferred to the buyer, he is only the possessor, and still the ownership is with the seller. So these are the various crucial moments to know at what particular time the risk passes or the property transfer passes from seller to buyer, to know the rights and liabilities of seller and buyer. So there are three categories. In case of ascertained goods, the contract, the goods are immediately transferred. The property in goods is immediately transferred, provided the contract is for specific goods and the goods are in a deliverable state and the goods are not required to be weighed or measured for determining the price. So the rules in case of specific or ascertained goods, that the property, the ownership is transferred immediately, provided the following conditions are satisfied: that the contract is for the specific goods, the goods are in a deliverable state, and the goods are not required to be weighed or measured for the determining the price. So the immediately the buyer becomes the owner and the risk passes to the buyer. Next is rules relating to transfer of ownership of unascertained goods. It will be transferred when the following conditions are satisfied. The goods must have been ascertained. So first you have to ascertain the goods. The goods must have been unconditionally appropriated by the buyer or to the sale to the by the buyer to the by the seller to the buyer. The contract to sell unascertained goods is not complete sale. It is an agreement to sell, and it will become a sale when the goods are ascertained and it is unconditionally appropriated by the seller to the buyer. So, and the third rule is goods sent on approval or on sale or return basis. So in this, the buyer is given option either to approve the goods, or if he is approving, he can retain. So after accepting, the goods are, the ownership is transferred. If he is rejecting, he is returning the goods, the ownership is not transferred. So these are the three rules which is to be followed to know whether the ownership of goods is transferred or not, and to determine the rights and liabilities of between the buyer and seller. Another rule is delivery to carrier. If there is no reservation of right of disposal, it is deemed have unconditionally appropriated the goods to the contract. So in case of delivery to carrier, it is presumed that it is delivery to the buyer if there is no conditions to be fulfilled before taking the delivery from the carrier by the buyer. So that is given under section 23 subsection 2, that delivery to carrier is deemed to be delivery to buyer if there is no conditions to be fulfilled by the buyer before taking the goods from the carrier. Next is reservation of right of disposal. So the seller may reserve the right of disposal until certain conditions are fulfilled. For example, where the buyer is to pay for the goods before delivery, where by the bill of lading or railway receipt, the goods deliverable to the order of seller or his agent, or where the seller draws a bill of exchange and send the same along with bill of lading or railway receipt to secure buyer's acceptance or payment of bill of exchange. In all the above cases, the property in good does not pass to the buyer until the goods imposed by the seller are fulfilled. So whatever the conditions imposed are fulfilled, the property is not transferred from buyer or seller to the buyer. So this is an exception, section 25, in which the property is not transferred and the seller is reserving the right till some conditions are fulfilled before the delivery is given to the buyer. Now, the last point in this chapter is risk prima facie passes with the property. That is, the rule is respirit domino, that is, the loss falls on the owner. Exceptions to the above. The section 26 says that the person who is the owner of goods, as soon as the property is transferred, the ownership is transferred from seller to buyer, the risk is also transferred from seller to buyer. Even the goods are in possession of seller, if it is destroyed, the loss is bared by the buyer unless there is a contract to the contrary. Okay, so there are exceptions. If there is a parties agree that the loss will be still bared by the seller, in that case it will the rule will not be applicable even the property in goods is transferred to the buyer. So there are section 27 is transfer of title by person, not the owner. So the general rule is only the true owner can transfer the property. So the title, you cannot get a good title to the goods if you are purchasing from a person who is not the owner. So that is the general rule, that only the person who is having a title to the goods, he can sell. But there is and the rule is expressed by maxim nemo dat quod non habet, that is, no one can pass a better title than he himself has. But there are certain exceptions. If the buyer is purchasing in good faith without notice, in that case, he gets a good title. So there are certain exceptions given from section 27 to section 30, in which even the buyer is purchasing from a person who is not having title to goods. He is getting good title provided he has no notice and he purchase in good faith. First is sale by mercantile agent. So whenever a mercantile agent is approaching to sell the goods on behalf of the seller, it is presumed that he might have that authority. And if the buyer is purchasing the goods from mercantile agent, he gets a good title. Second, sale by joint owner. If one of the joint owner is selling the goods to other without authority, and the buyer is purchasing without notice, in good faith, he gets a good title to that goods. Then sale by person in possession under a voidable contract. So if a buyer by fraud has taken possession of goods and sells to the other party, and the other party purchase the goods in good faith without knowledge that it is he has taken the goods under a voidable contract, he gets a good title. Other is sale by seller in possession after sale. So if the seller again sells the goods and the other buyer is not knowing the previous sale, in that case also the buyer gets a good title to the goods. Next is sale by buyer in possession. So sometimes the buyer is in possession, though he may not be the owner of goods. In that case, if he sells the goods to the other buyer, in that case, if the other buyer is purchasing in good faith and without notice, he gets a good title to the goods. Next is transfer of title by estoppel. If the true owner stands by and allows an innocent buyer to pay over money to a third party who profess to have the right to sell an article, the true owner will be estopped from denying the third parties to right to sell. So if in front of a true owner, if you are saying that I am the owner of these goods and the true owner is not speaking anything, so he will be estopped from saying that the third party is not having that right to sell. So by estoppel, he will get a good title to the goods. Sale by unpaid seller. So unpaid seller, he can, if he is having possession, he can sell and he can transfer a better title. Sale by person under other laws. So in case of pawnee, that is pledgee. So if you are pledging the goods and if the principal along with the interest is not paid, and after giving notice, the pledgee can sell the goods and the other party can get the good title. In case of finder of lost goods also, if the true owner is not found and if the goods are of perishable nature, the buyer gets a good title. And other laws are the official assignee, official receiver, liquidator. So they are not the owners, but they can convey better title than they have. So these are the exceptions in which the protection is another protection is given to the buyer, provided he purchased the goods in good faith without notice of previous whatever circumstances. So he will get a good title, even the other party is not having right to transfer the goods. That is exceptions to the rule nemo dat quod not habil. The next chapter is performance of contract of sale. So that the provisions are given from section 71 to 44. So once the contract is made, now it is up to the parties to perform. So this is the last stage in which the seller and the buyer has to perform as per the contract. So the performance of contract of sale of goods implies delivery of goods by seller and acceptance of delivery of goods and payment of price as per the contract. And the parties are free to provide any terms like in their contract regarding time, regarding place of delivery, regarding manner of delivery, and regarding acceptance and payment of price. So if there is no express provisions provided under the contract, the section 31 to 44 will be followed to know what will be the time and what will be the place of delivery of goods. So section 31, that it is the duty of seller to deliver and it is the duty of buyer to accept the and pay the price. Section 32, delivery, generally the payment and delivery are concurrent conditions unless there is a contract to the contrary. Section 33, delivery may be made by doing anything that shall be treated as delivery, means they should be put in a deliverable state. Section 34, effect of part delivery. A delivery of part of goods in progress of the delivery of whole has the same effect for the purpose of passing of property in such goods as a delivery of whole. But a delivery of part of goods with an intention of severing it from the whole does not operate as a delivery of remnant. So if the contract is there that the goods will be delivered in installments, so it can be delivered in installments. Then section 35, it is the duty of buyer to apply for delivery. So the general rule is it is the duty of buyer to apply for delivery. Section 36 is relating to rules of delivery. The place of delivery will be as per contract. If it is not fixed, it will be the place where the contract of sale is made or where the contract of agreement to sale is made. Next, time of delivery. If the time of delivery of goods has not been specified in the contract, it must be made within a reasonable time. Goods in possession of third party. Where the goods are in possession of third party, there is no delivery by seller to the buyer until such persons acknowledges to the buyer that he holds the goods on his behalf. Time for tender of delivery. So it should be reasonable hours. During business hours, the seller or the buyer should ask for the delivery, and whatever the delivery expenses till the putting it in a deliverable state, it should be borne by the seller unless there is any other stated terms in the contract. So these are the rules relating to delivery. So other rules are, if there is a wrong quantity of delivery of quantity, it is the option given to the buyer either to accept or to reject. So if there is less, he can either accept and pay the price as per the contracted price, pay for the goods as per the contracted price, or he can reject the goods. If the goods are excess, he can accept. He can either accept as per the contract or what is contracted for, and he can reject the remaining excess goods, or he can reject all the goods. So these are the other rules relating to delivery. So whatever is decided by the parties, that is seller and buyer, the delivery of goods must be in that description or quantity. If it is wrong, the right is given to if the wrong quantity is delivered, the right is given to the buyer that he can reject the goods or he can waive his right and he can claim damages. Delivery to carrier or wharfinger. So this is another duty cast on the seller. Delivery of goods to carrier or wharfinger is deemed to be a delivery to buyer as per contract. But the seller may make such contract with the carrier or wharfinger on the buyer's behalf as may be reasonable, having regard to the nature of goods and other circumstances of the case. So if the seller omits to make certain contracts, say for insurance, if the goods are lost, then the seller is liable for that. So when the goods specially are sent by a route involving sea transit, in circumstances in which it is usual to insure, the seller shall give such notice to the buyer as may enable him to ensure them during sea transit, and if the seller fails to do so, the goods shall be deemed to be at his risk during such sea transit. So this is another protection given to the buyer, that at the time of delivery, it is the duty of seller to make all formalities so that there is a safe delivery of goods to the buyer. Otherwise, and he should inform to the seller by what mode of transport he is delivering the goods. Otherwise, it will be the seller's risk if the goods are destroyed or damaged in transit. So this is another protection given to the buyer. Risks where goods are at distance place. So if the buyer is asking the goods to be transit at a distant place, then it was contracted for uh, the uh, all the expenses are to be borne by the buyer. That is, he has the risk of deterioration during the transit if he asks that the goods should be delivered at a distance place. Then buyer must be given an opportunity of examining the goods. Section 41. Section 42, acceptance. Means when he is intimating to the seller that he has accepted the goods, or when the goods have been delivered to him and he does any act in relation to them which is inconsistent, means he is reselling the goods in that case also. Or when the time is given, if the time is lapsed, or if the time is completed and he has not rejected the goods, in that case it is deemed that he has accepted the goods. Then once he has section 43 is, if the buyer is rejecting the goods, he is not bound to return the goods. Means it is the duty of seller to take the goods back, and it is only the duty of buyer to intimate the seller that he has rejected the goods. That is given under section 43. Section 44, liability of buyer for neglecting or refusing the delivery of goods. So if nothing is fault on the part of seller and the buyer is neglecting in taking the goods, the buyer is liable for any loss which is caused to the goods to the seller. That is given under section 44. And now the last point is unpaid seller. So some sort of protections are given to unpaid sellers also. Unpaid seller means when the price is unpaid, or when a bill of exchange was issued or negotiable instrument has been received and which has been dishonored, which has not been fulfilled by reason of dishonor, the seller is said to be unpaid seller as per section 45. So there are certain protections given to seller also. That is, right of lien, means he can keep the goods if the goods are in possession till the payment is given to him. So the first right given to the unpaid seller is right of lien, that he can keep the possession till the goods till the payment is paid by the buyer. Next is right of stoppage in transit. So the right of stoppage in transit is a right of stopping the goods in transit after the unpaid seller has parted with the possession of goods. So he has to give notice to the carrier that the goods should not be delivered till the payment is paid. So after delivering the goods, if the seller comes to know that the buyer becomes insolvent, so he can inform the carrier that the goods should be stopped and it should not be delivered to the buyer. So the buyer, this is right of stoppage in transit. It is available when the goods are already delivered to the carrier, but before it is delivered to the buyer, he can exercise this right of stoppage in transit. Next is duration of transit is when the transit comes to an end when the goods are already delivered to the agent or to the buyer. So the duration of transit is till when the delivery is not done completely and the buyer is not received the goods. Till that moment, the right is given to the unpaid seller that he can stop the goods in transit. Once the goods are delivered, or the carrier holds the goods as a bailee of buyer, the transit comes to an end. Next is how stoppage in transit is affected. He should give notice to the carrier. And right of resale. The third right is right of resale. So in spite of notices, if the buyer is not ready to pay, the buyer can resell the goods, and whatever loss after giving notice and whatever loss is caused, he can recover from the buyer. If there is any profit, the buyer is not entitled to the profit. But if without giving notice, the seller is reselling the goods, the seller cannot claim damages in case of loss, but the buyer can claim profits, whatever is accrued by resale of that goods, if there is no notice given to the buyer relating to resale of goods. So this is relating to rights of unpaid seller. And the last topic is breach of contract, suit for breach of contract. So if there is a breach by buyer, the seller can file a suit for price, special whatever damages which are given under section 73 of Indian Contract Act that can be claimed by the seller. Suit for damages for non-acceptance of goods. So first, suit for price. So whatever the price of goods he can claim. Second, whatever damages he has sustained because of non-acceptance, that is section 56. Then suit for damages for repudiation of contract by buyer before due date. So if there is an anticipatory breach of contract, in that case, he can either file on the same date, or he can wait till the due date and he can claim damages. He can file a suit. So that is given under section 60, that is suit for damages for repudiation of contract by the buyer before due date. So two options are given. He can either file a suit immediately, or he can wait till the date of performance. In both the cases, the difference is the compensation will differ. What will be the compensation on that date? It will be given if he is filing immediately, or if he is filing on the date of performance. Whatever the rates will be there, the compensation will be paid accordingly. And suit for interest, so he can also, whatever loss is caused, he can also claim interest on the money which is due from the buyer. And similarly, if there is a breach of contract by seller, there is a buyer can file a suit for damages for non-delivery of goods. He can also claim for specific performance at the discretion of court. So as you know, a specific performance is at the discretion of court. It is not a matter of right. In what cases specific, in cases of immovable property, there is a presumption that the damages are not sufficient, adequate, and the court may give specific performance. But as far as movable property is concerned, the court is to be satisfied that the damages are not adequate in satisfying the buyer. So in that cases, or there is no criteria. So if suppose there is some sort of attachment to the goods, for example, there is a contract of sale of a painting by dead painter, and so it is not easily available in the market. In that case, the buyer can claim for specific performance of contract, and at the discretion of court, it can be given. Suit for breach of warranty, he can also file a suit for breach of warranty. He can claim compensation. Then suit for damages for repudiation of contract by seller before due date. So similarly, he can either wait till the performance, or he can file immediately. And in that case, the compensation will differ as per the rates prevalent at the time of performance, or immediately at the time of breach of contract. And whatever, if he has paid the price, he can sue the interest. The court may award interest at such rate as it thinks fit on the amount of price to the buyer from date on which the payment was made. So he can also claim interest, whatever amount he has paid. So chapter 7 is miscellaneous. So auction sale, there are certain rules relating to auction sales also for the protection of buyer. So in auction sale, the auctioneer announces its completion by the fall of hammer or in other customary manner. And until such announcement is made, any bidder may retract his bid. The seller is also given right to bid, provided he has disclosed his interest. Otherwise, it will be considered not lawful, and it will be not a valid auction sale. But there can be reservation of price. The sale may be notified to be subject to a reserve or upset price. So there may be, the seller may reserve the price that if it is not bid till that amount, he can withdraw the sale. So it is also provided that under section 64 that the price can be reserved in auction sale. And last, use of pretended bidding. It is also for the protection of buyer that if the seller makes use of pretended bidding to raise the price, the sale is voidable at the option of buyer. So in auction sale also, though it is in the open market, if there is any pretended bidding, the buyers are protected. And if afterwards it comes to know that there were some pretended bidding and the price was escalated, so the buyer, if the burden of proof is on the buyer, and if he proves, then the contract can be avoided. So with this, we have completed.
Anybody has any questions, you can please post the same in the chat window. Sir, many of the participants have requested that the PPT to be shared with them.
Yes,
so,
yes.
So on behalf of our council, we assure all the participants that we will share the PPT via email. So you will get it. There is nothing to worry. If any questions are there, please.
Yes, there are many questions, I think. But
no, sir. I've just gone.
It is already late. Sorry, I have taken 30 minutes extra time. Because it was a wide, vast topic. So I was very
Sir,
fast.
there is a question which I had read in the chat box.
Yes.
Regarding, can builder take GST at the time of agreement to sale?
So it is an immovable property, right? And it is not deal with the Sale of Goods Act.
No problem.
So, yes. So at the time of agreement to sell, he can. Because what is the GST rules are there? It is relating to services. It comes under services and under so till the possession is given to the allottee, the developer can claim, they can charge GST, and it is to be paid to the it is as per the GST rules, okay, and it is related to immovable property, and here we are discussing with movable property. So the rule relating to GST in that case will be a transfer of immovable property, and not in case of agreement to sale of goods, it is not applicable. But in case of agreement to sell immovable property, when you are purchasing an apartment, in that case, it will be applicable.
So we have another question from Advocate Vinika Nadar saying that whether GST applies when we purchase a pre-owned car, a bike, etc., like normally known as second-hand car or bike. So whether GST applies in that case also, or whether sale of goods applies. I think the question is whether the Sale of Goods Act apply when the purchase is of pre-owned car or second-hand car or bike or something of that sort. That is what the question which I can interpret.
Okay. So there are, you can see, it depends. I don't think that there is GST is applicable to.
Sir, sorry to interrupt, sir. It is not about GST, it is about the Sale of Goods Act. So supposingly I purchase a pre-owned car or bike, whether the Sale of Goods Act applies to that transaction. This is what the question is, which I can understand.
Okay. So in that case, it won't be because it is paid already. The tax is paid in case of movable property. So there will be no, in case of resale, there will be in old second-hand car, there will be no GST applicable.
I think, sir, no more questions coming up. Basically, all are the. No, sir. See, there is a clarification coming from Nadar Madam. So her question was that Sale of Goods Act applies to a transaction where the person purchasing the goods is of pre-owned car or bike or something of that on that lines. So her question was Sale of Goods Act.
Okay. Yes. If it's you see that there is a freedom of contract, right? And if you impose certain conditions and warranties even in a second hand or any resale transactions, so if it is you are mentioning that terms and conditions, it should be at the whatever the between the parties to decide. The freedom of contract is there to decide whether this will be applicable to. So it is still applicable. So if you are making a certain contract of sale of goods, even of resale, okay, and if there is any condition and if it is not fulfilled, and still you can reject the goods and you can claim compensation from the other party. Okay. Yes.
So another question which is coming up is from the point of view of exam, which according to you are the most important or most likely questions or topics which the participant should stress more emphasis on?
Yes, yes, sure. So the first is, what do you mean by conditions and warranties? So on conditions and warranties, the question can be, probable questions can be asked. So you concentrate, because you see there are 10 acts, and there is 40 marks allotted to these 10 acts, and 4 to 5 questions will be on Sale of Goods Act. Okay, so the question can be on conditions and warranties, especially implied conditions and warranties. The question can be on sale and agreement to sell. The question can be on when the property in goods is transferred. That is, the question can be on rule of caveat emptor, exceptions to the rule of caveat emptor, transfer by not owner, section 27, okay, and the remedies available. So these can be the probable questions. So the most important is section 11 to section 17 and section 18 to section 30. So these are the most important sections on which the questions can be asked. So you concentrate on where the protection of buyers are there in Sale of Goods Act. So the law has given protection by inserting implied conditions and warranties, also by the rule of nemo dat non quod habit, that even the buyer is purchasing from a person who is not the owner, he is protected provided there is no notice and he purchases in good faith. So what are the circumstances, and when the property is transferred, when the risk is transferred, to determine the rights and liabilities of buyer and seller. And other is when the property is transferred, and the rules relating to delivery is also important. You can so only 4 questions I am expecting. So this will be enough, I think, from conditions and warranties and from transfer of property and sale and agreement.
I think, sir, there are no other questions, and
You want this PPT, I think.
yes, that is the most popular thing. And as I've announced that sir has consented that he'll share the PPT and with BCMG, and BCMG will share to all the participants via email. So
yes, sir. I will share today itself. I will share with you. Yes, please give me the on which number I can share.
Sir, yes, sir. The official email ID of Bar Council that will be communicated to you, sir. That we will communicate to you. Okay, sir.
Thank you, sir.
With the permission and the Bar Council of Maharashtra and Goa would like to thank you for your valuable time and spending so much of time on a Sunday evening and enlightening the students who are appearing for the exam. And like a true professor, you have gone in depth and given minute details of the Sale of Goods Act in when it compared to the Consumer Protection Act. And from exam point of view, the PPT slide is being so nicely made that it is so informative that even on going to the PPT slide, the participants can understand the act. And I've also explained to us the most likely questions which are going to be asked. So I think, sir, you have done justice and have enlightened the student to the fullest. And we are really thankful to you for your time and guidance, and we will trouble you in future for any lectures on as these are continuous lecture till the dates of exams are announced. So once again, thank you, sir, for your valuable time. And participants, there is announcement tomorrow. We are having lecture of former Judge Bombay High Court, Shri R.C. Chauhan, who has also served as a president of State Consumer Commission. And he is going to take a lecture on the topic of journey from journey to judgeship. So basically, we all the participants are appearing for the exam to be appointed as judicial officers. So therefore, the mindset and the change in the mindset from a lawyer to a judge is something really very important. And no better person than Justice R.C. Chauhan to guide us. So tomorrow, sharp 6 p.m. we'll be there online virtually, and you are also all are requested to join at 6 p.m. sharp. So with this, we conclude our today's session, and thank you all for joining in and continue joining in large numbers. And have a good evening. Sir, Sharat sir, can you please end the meeting?